supports its mission needs to comply with the law. And secondly, whether the district court's rulings should be respected. So I think what the justices' questions were focusing on were both of those issues. It was an interesting argument. It was well argued, I think, by my opponent, the Solicitor General. The justices are likely to decide the case sometime within the next 2 months because there's only one more exercise. These exercises have continued. The Navy has been able to continue to train despite the position they took that they couldn't. They've been training ever since February when the injunction was issued. It's one of the points that I made, is that the training has continued unabated and unaffected while at least mitigating some of the harms to the environment, which is the point of this case. And those harms are really significant. The noise, the sound intensity produced by sonar is 2,000 times louder than a jet engine. If you imagine what it would be like to have a jet engine right here, we would scatter. And that is what happens to marine mammals. And it causes a whole variety of harms, ranging from hemorrhaging and death to behavioral displacement, hearing loss. Whales' primary means of communication, navigation, foraging for food is sound. You damage that, you damage the whale in a very significant way.
Mr. Kendall, you were asked by a number of justices. Look, they said, who are we? To the President, the Department of Defense, they say they need this for the national defense. Justice Breyer even said that's what the military does. It ruins the environment. I mean, that's what bombing exercises do. So who are we to second guess them in something like this?
It's a very good question, but the premise of the question is wrong. Because this judge found that there would be no compromise in the training. So there was no second guessing going on. She had deference to the Navy. They had declarations they submitted, but she also had the evidence of the prior exercises that they have conducted. What that evidence showed is that repeatedly they have trained with just these mitigation measures, and they have trained just fine. They have fulfilled their mission. The fact is that they can protect the environment and train the sailors at the same time.
Are there broader implications beyond the whales? Are there broader implications here for other military activities that might be deemed, not to fall under environmental statute?
The larger issues in this case had to do with the executive trying to trump NEPA, the National Environmental Policy Act, using a emergency circumstances regulation that CEQ had used for the very first time to try to trump a district court order. If the executive branch can say after an Article 3 court has ruled, your ruling doesn't count, now you have to go back and do it again because we disagree, then our constitutional framework would have just undergone an earthquake. I mean, that has not been the law in this country since the Constitution was enacted in 1789, and 3 years later, the Supreme Court said exactly what I have said today, which is that the executive branch cannot sit as a court of errors on an action by an Article 3 court. And so here we are, more than 200 years later, and they have for the first time tried to argue that the executive branch can trump a judicial order. That's unconstitutional.
Anybody else?
Other questions?